for 4 counts of involuntary manslaughter based on her son's actions in a school shooting. Closing arguments are just beginning. Let's go in live.
And I'm going to spend some time going through the elements of the crime. I want you to know that I have been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened, and I also want you to know that I really appreciate that, and I know the court does too. I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts, and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but we're emotional for this. Because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty, and I believe we've done that. The defense also has an important job, to advocate and argue for their client, and they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when 2 sides disagree, to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter, she is charged with. This case is based on 2 theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on 2 specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. 2, she knew of the facts that gave rise to the duty. 3, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then 4, the death of the victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these 4 individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts. Some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following 3 things. 1, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you I have 2 theories. We're prosecuting and charging based on 2 theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's 2 alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tamir. We all know that she didn't and wasn't able to save Tamir. We heard from Cammy Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm 6-hour to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the SIG and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis, and he said, "Do you know where the gun is, and do you know where it came from, and do you need help?" And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase, and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lot is and the trigger lot statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory, and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Woodrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing that's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me for that.
I would object.
It's my opening. It's my closing.
What a witness tells her all the time that it's not evidence.
Okay. I'll move on. Okay. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting. Because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to.
All right, prosecution closing arguments underway. Quick break. Want to get you right back into that courtroom. Stay where you are.